Ladies and gentlemen, welcome back to the Indie Zone podcast. My name is Kathy. One of the lengthier court orders on the motions in limine that were filed back in February 2025, some by the state, some by the defense, is the order filed April 18th on the defendant's motion in limine regarding Rylene Nowlin and touch and contact DNA. If you read this document, it basically grants in part the relief that the defense is seeking but denies other relief. Let's read this and learn what the court ruled here. Introduction, page 1, it says, defendant moves in limine to exclude the testimony of Rylene Nowlin, the lab manager with the Idaho State Police Forensic Services Laboratory, who was disclosed by the state to testify about, quote, touch, end quote, DNA, and the transfer of DNA generally, and more specifically, that the DNA located on the sheath was more likely the result of a direct transfer. This court order continues. Defendant argues that Ms. Nowlin's testimony, as well as any other testimony referencing the terms, quote, touch, end quote, or contact, quote unquote, DNA, and or purporting to be an opinion about the means or mechanism how the DNA ended up on the sheath is irrelevant or impermissible under IRE, that is Idaho Rule of Evidence 403, and fails to satisfy IRE, another Rule of Evidence 703. It then goes on to say, oral argument on the motion. It says here, after which the court took the matter under advisement. That means that he took the combination of the briefings. That would be the original motion, the response, and the reply. That's the briefings. And then oral argument, which occurred on the 9th of April by both sides, trying for one last time to persuade the judge to either grant, if you're talking about the defense, or deny this motion per the state. Court took this under advisement. He took everything that he had before him, and he is now issuing a written ruling. Here is his decision. The court does not find exclusion of Ms. Nowlin's opinions is warranted. So therefore, that's the denial part. Ms. Nowlin will be able to testify at trial. However, here's the granting part. The court requests that the parties instruct their witnesses to avoid the use of the terms, quote, touch DNA, quote, contact DNA, and, quote, trace DNA. Please read this motion. It is one of the first filed by Becca Barlow, who has been involved in the field of DNA since the 1990s. And she wrote this motion. The court then, under Section 2 standards, he goes into the admissibility of expert opinion testimony. These are not lay witnesses. These are expert opinions. These are people who either side want to be able to get in front of that jury using their skills, knowledge, and experience to explain something to help the jury understand a certain matter. This motion and order deals with DNA. As I've said, it is very long. If you'd like to understand the court's reasoning, please review this document and know that the ruling is granted in part, denied in part. This is Kathy. Thanks for joining us here today.